to, let's see, Mr. Meyer, you are here. Miss Adams, would it be possible to get the jail? Danielle Rosenberg from the jail, please.
Okay.
All right, and Mr. Goldstein, I will take you next. Mr. Myers, I have requested your client, so we'll get you on your way.
Thank
And
you.
then, yep. Mr. Goldstein, who do you have?
I have Mr. Zachary Rosenberg and Mr. Alan Crystal.
We have Crystal. So Zachary Rosenberg is in the courtroom?
He should be, Your Honor.
Okay, okay. All right. Take care of Mr. Crystal. All right. Mr. Crystal, can you hear me? No. Mr. Rosenberg, you want to come up to the podium? All right, I've sent instructions to Mr. Crystal. Are you on Rosenberg? Okay. All right, so Mr. Crystal, are you connected to audio?
Yes, I can hear you now. Thank you.
Okay, this is in the matter of the people of the state of Michigan versus Alan David Crystal. I have file number 22-20896FH. I have Dave Goldstein on behalf of Mr. Crystal. And I have Isaac Sneed appearing on behalf of the people. This is the date and time scheduled for a pretrial conference in this matter. Mr. Goldstein, how do you wish to proceed today?
Your Honor, Mr. Sneed and I have been doing some negotiating, but we have been unsuccessful in resolving the matter, so I think we need to set it for trial.
Okay, so. How many days do you expect this trial to last?
2 days at the most.
2 days. This is not an exceptionally older file. So Ms. Adams, I'm looking for a 2-day trial date, probably in September, October, possibly. Yeah, October better for you, Mr. Goldstein?
Either one, Your Honor.
Okay.
All right.
Mr. Myers, do you need to speak with your client today?
No, Judge. We're ready to go on the record. Although I
Okay.
believe that Ms. Muir just
Hold
sent
on. Hold on. I didn't want to go to your case yet. I just wanted to know if you need a breakout room so I could pop in there. Hold on, I'll call it. All right. I'm sorry, Ms. Adams.
That's okay. We could start one on Wednesday, September 13th.
That should work.
All right, so September 14 of 23, Wednesday trial dates start at 10:30 in the morning.
Judge, that was the 13th.
Oh, I'm sorry. But it was a Wednesday?
Yes.
Yes.
I got part of it right then. All right, so that would start at 10:30 in the morning, but on Thursday and Friday, it would start at 9. And if we're doing September 13th trial date, I'm going to do, Mr. Goldstein, are you available on September 6th for a pre-trial?
I believe so, Your Honor. Yes.
All right, so I will set September 6th as the deadline for all motions, motion and limines, jury instructions, and voir dire questions will be due as well on that day. And we can discuss any issues we have at that time. So, Mr. Crystal. Okay, so maximum penalty on this offense 15. All right, and was it my understanding, Mr. Goldstein, a 4th degree was offered with no upfront jail for Mr. Crystal?
Yes, Your Honor. Just so the court is aware, the hang up, of course, was the SORA registration.
Okay. All right. Mr. Crystal, I don't know anything about the case, so I'm not making a judgment one way or the other. but understand if you're convicted at the time of trial, you will be remanded to custody. So on the off chance, you should prepare for that. All right. So I filled out a scheduling order, Mr. Goldstein, and we will send this out. And Mr. Crystal, we'll see you back for pretrial on September 6th and for trial on September 13th. All right. Okay. Thank you, Mr. Crystal.
Thank
All right, Mr. Goldstein, in the matter of the people of the state of Michigan versus.
Zachary Rosenberg.
I had the wrong Rosenberg. Okay, in the matter of the people of the state of Michigan versus Zachary David Rosenberg, file number 23-21322FH, I have Dave Goldstein appearing on behalf of Mr. Rosenberg, and I have Isaac Sneed, I have Douglas Hartog
Yeah.
appearing on behalf of the prosecutor's office. So, Mr. Goldstein, how do you wish to proceed today on behalf of Mr. Rosenberg?
Your Honor, Mr. Hartung and I have pretty much resolved the matter as far as a plea agreement is concerned. However, there are sentencing issues I would like to discuss with the court before we enter the plea. So I'd like to set up a Cobb's conference at the court's convenience.
All right, Mr. Goldstein, do you have some things to take care of in front of Judge Olsaver at all?
Today? No, Your Honor.
Yes.
I do have other matters, but not in front of Judge Olsaver.
Okay, I could, if you both would like, I could set this over till 10:30 or 11 for a bench conference.
Your Honor, I've got other matters in other courts. I don't think I'll be available. And I think Mr.
Okay.
Hartung indicated he had a busy morning this morning also.
Okay, so Ms. Adams, do I have any time tomorrow morning?
I could do Friday, Your Honor, I could do Friday morning.
Mr. Hartung, are you available at 8 o'clock on Friday morning?
I'm available at 8 o'clock on Friday.
Okay, so Mr. Rosenberg, I'm going to set this over to May 12 at 8 a.m. in the morning. And just zoom back in because my notice won't make it to you in time. Or the stipend order that Mr. Goldstein and Mr. Hartung will do. But we'll see you back on May 12 at 8 a.m. in the morning. All right, Mr. Rosenberg? I was looking at my Zoom. Thank you.
Okay.
All right, you can zoom in or you can come in person.
Okay.
So whatever you would like, all right?
Okay.
Thank you.
Thank you.
Thank you, Your Honor. Thank you.
Thank you. All right, in the matter of the people of the state of Michigan versus Danielle Cope Rosenberg, file number 23-21343FH. I have Attorney Sean Myers, MYERS, P78687, appearing on behalf of Ms. Rosenberg. And I have Isaac Sneed appearing on behalf of the people, and I have Ms. Rosenberg appearing from the Lenawee County Jail. This is the time scheduled for a pre-trial in this matter. Mr. Myers, how would you like to proceed today?
Judge, last time we were here, we had attempted to put a plea on the record. We're still working on that. And I'm hoping for another 2 weeks to discuss this matter further with the client and the assistant prosecutor. I understand the prosecutor's office is also in favor of an adjournment.
Okay, so my next available is June 7 at 8:30 in the morning. Are you available that day?
I am.
All right, so Ms. Rosenberg, I will set this over for another pretrial on June 7 at 8:30 in the morning. And you need to, Mr. Meyer, you will prepare the stipend order to adjourn?
Oh, yeah, I'd be happy to do that.
Okay, yeah, so we do the notice at the time of arraignment, but for adjournment requests, you would do the stipulation in order to adjourn. And Mr.
Yeah.
Sneed, may you sign your name with permission?
Yes, please.
There you go.
No problem.
So-
I can do that, Judge.
All right, thank you, Mr. Myers. Ms. Rosenberg, I'll see you back then. Thank you.
Thank you.
Thank you. Have a nice day.
You too. All right, Mr. Daniel Margosian. Oh, your client's still on the waiting room. Let me bring him back. Mr. Hartung, my horse won the race. My horse won the race.
Pardon?
Mage won the race.
Yeah, I know, you braggart.
All right, Mr. Rowley, can you hear me?
Yes, ma'am.
All right, this is in the matter of the people of the state of Michigan versus Joshua Dexter Rowley, file number 23-21263FH. I have Michael Dagger Margosian appearing on behalf of Mr. Rowley, and I have Isaac Sneed appearing on behalf of the people. Mr. Dagger Margosian, this is the date and time set for a pretrial. How would you like to proceed today?
Your Honor, good morning. Michael Dagger Margosian for Mr. Rowley. Your Honor, there is a plea offer in place at this time. Mr. Rowley will accept that. The plea will be to count one as charged in an agreement for no habituals to be added to that. Second, there's a sentencing agreement for no upfront jail, and any jail would be deferred.
Okay. All right. Is that a correct recitation of the plea, Mr. Sneed?
I just want to specify that sentencing agreement's a Cobb's agreement, not a Killebrew agreement.
That was a Cobb's agreement.
Sure.
Thank you.
Okay. Mr. Sneed, I don't know if you can move your microphone or something because you're very faint. All right. Okay, so Mr. Rowley, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, can you state your full name for the record?
Joshua Dexter Rowley.
Okay, you can put your hand down. So, Mr. Rowley, you've heard the statement of your attorney and the prosecuting attorney is that your intention to plead guilty to count one police officer fleeing third degree, which carries a maximum penalty of up to 5 years in prison and or a $5,000 fine. The Secretary of State will or shall suspend your operator or chauffeur's license not for a period of not to exceed 5 years. So is it your intention to plead guilty to that count?
Yes.
All right. Now, are you satisfied with Mr. Dagger Margosian as your attorney and the advice that he has given you?
Yes, ma'am.
Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court other than the Cobb's agreement to no upfront jail. Is that correct, Mr. Sneed?
Yes, Your Honor.
And Mr. Dagger Margosian?
Yes, Your Honor.
Is that correct as far as you're aware, Mr. Rowley?
Yeah.
Okay. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you, sir?
Understand.
Do you have any questions? Yes or no?
Comment.
Okay. How do you wish to plead to the charge that on or about November 1 of 2022 in the city of Tecumseh in the county of Lenawee that you did commit the offense of police officer fleeing third degree? Guilty or not guilty?
Guilty.
All right, so we're kind of getting some distortion. So if at all possible, could you kind of move the phone a little bit closer to you so we're picking up the audio better? All right, so guilty or not guilty?
Guilty.
Oh, excellent. Thank you. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, ma'am.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, ma'am.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Steen?
No, Your Honor.
No, Your Honor.
Mr. Dagger-Bogosian?
None.
Okay. Has your attorney promised you any particular sentence or estimated what your sentence will be other than the no upfront jail or a deferred jail term?
To probation, and he told me my guy, yes,
Okay, okay. Is it your own choice to plead guilty?
yes,
All right, so Mr. Rowley, on November 1 of 2022, were you operating a motor vehicle in the city of Tecumseh in the county of Lenawee?
yes, ma'am.
All right, and at the time you came in contact with the Tecumseh police officer, Randy Escott, was it daytime or nighttime?
Nighttime,
Okay, and so did the police officer pull behind you and turn his lights on?
yes,
Okay, and by those lights being turned on, were you aware that it was a police officer behind you?
yes, ma'am.
And by him turning his lights on and being behind you, did you understand that he meant for you to pull over?
Yes, ma'am.
Okay, and were you able to see the car or just the lights?
I seen the car too, the lights.
Okay, so you knew it was a police car?
Yes.
Okay, and instead of pulling over, did you actually speed up?
Yes,
And then increase you sped up, and would you agree that you were driving over the speed limit, which was 35 miles per hour at that time?
yes,
Okay, and did you eventually pull over or did you get in an accident or?
I ran out of gas.
Okay, Mr. Sneed, are you satisfied?
Yes, Your Honor.
All right. Has the court complied with MCR 6.302 B, C, and D? Mr. Sneed
Yes, thank you.
and Mr. Dagger-Margosian?
Yes, Your Honor. Thank you.
All right. Accept the plea has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made a Cobb's agreement regarding upfront sentencing, but other than that, has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. Mr. Dagger-Margosian, I was going to set this for sentencing on June 29 at 8:15 in the morning. Are you available that day?
June 29. June 29 is good. Thank you, Your Honor.
All right. So, Mr. Rowley, I will set this for sentencing on June 29 at 8:15. You have two choices. You can appear in person or you can agree to appear via Zoom. How would you like to appear for sentencing?
Zoom, please.
Okay, so I will have that be a Zoom sentencing. Now, Mr. Rowley, I'm going to put you in a breakout room with Ms. Holly from the Michigan Department of Corrections. She's going to give you some instructions. One will be that you're going to need to fill out a packet. You're going to have to come meet with them. Make sure that you actually show up and meet with them. Be surprised how many people don't. And that when you meet with them, you're truthful about your background and also the events that occurred. The Michigan Department of Corrections will prepare a pre-sentence report. We'll provide a copy of that to Mr. Dagger-Margosian. He'll review with you that document before sentencing. We'll see you back on June 29th at 8:15. So I've opened the breakout room. Ms. Holly and Mr. Dagger or Mr. Rowley, you can join that breakout room.
Thank you.
Again.
So what do I got here? So Ms. Hennigan and Mr. Hartung, you have one together?
Your Honor, I have a case that I took over from Mr. Daly, and I'm not sure the prosecutor is on.
Would,
McGrath.
and who are you here for?
You're for Bailey Manske with Mr. Mawad.
Mr. Mawad's here. Mr. Mawad,
Yes, Judge. Yes.
let's see if your client's this unnamed phone. Ms. Underwood, do you need to speak with Mr. Spearman in a breakout room?
Probably just for a second, Your Honor.
All right. So Mr. Spearman, I'm going to assign you and Ms. Underwood to a breakout room. He's already gone. All right, I'm gonna sign this. There you go. All right. Now I have a gentleman, let's see, I have a gentleman with a beard, a black hoodie or a sweatshirt on. What is your name? You?
Rodney, Rodney Hill.
Okay, so I'm gonna rename you real quick. Mr. Hill, who's your attorney?
Sam Malaro.
All right, so. All right, so I've changed your screen name. Mr. Hill, Mr. Malaro's in front of Judge Olsaver right now. So I'm gonna pop you in the waiting room, and then when he gets here, I'll bring you back in, okay, Mr. Hill?
Okay.
Thank you.
Judge,
Oh.
Mr. Rowley's internet froze and I couldn't get any information off of him. I don't know if he's coming back or not. So all I got was a number. I didn't get his phone number or anything.
Okay, hold on. I think this is him right here.
Okay.
Mr. Mawad, your client's not in jail. You said Manske?
Right.
And I don't think this is him logging in. I think this is Mr. the other
Oh,
guy.
she's not in the courtroom, Your Honor.
Oh, there she is. She's sitting in here. Dr. Mike, come up to the podium. And you said, who is your prosecutor on this, Mr. Moore?
It's Mr. Hartung. Mr. Hartung.
All right, so Miss, you want to just step up to the podium. So this is in the matter of the people of the state of Michigan versus Bailey, is it Linnell?
Linnell.
Linnell Manske, file number 22-20924FC. I have Elias Mawad appearing on behalf of Mr. Manske, and I have Douglas Hartung appearing on behalf of the people. This is the date and time set for a retrial. Looks like I don't have a few notices of hearings for adjourning out since January, but that's okay. So Mr. Mawad, how do you wish to proceed today?
Your Honor, Mr. Hartung and I have talked, and I've also talked to Mr. Manske. Mr. Manske is going to be pleading to a child abuse second degree, and if I'm correct, the child abuse first degree would be dismissed.
That's correct, Ron.
Okay, so,
We would move to add that count to the information and provide the court a copy later on today. That's acceptable.
so we're gonna, yep, that's fine. So plead guilty to count 2, child abuse second degree. And the maximum penalty of that is
10 years.
10 year. Okay, any other requirements? under
No,
that
not
statute?
not for initial offense. No, you're.
Okay, all right. So Mr. Manske, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, so Mr. Manske, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 2, child abuse second degree, which carries a maximum penalty of up to 10 years in prison? Okay, all right, so take a deep breath. Go ahead, there's some Kleenex right there. There's some Kleenex.
Judge, if I can help Ms. Manske out, Bailey, this is kind of getting your life back in gear by getting this matter resolved and moving on. We've got a little bit more work to do on the CPS case, but this is what we're going to do. Okay, so we're going to get through it. Okay. All right.
Take a deep breath. Breathe. Okay. So, are you satisfied with Mr. Mawad as your attorney and the advice that he's given you?
Yes.
Do you understand the maximum penalty for this offense could be up to 10 years in prison?
Yes.
Neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Hartung?
That's correct, Your Honor.
Mr. Mawad?
Correct.
Is that correct as far as you're aware, Mr. Manske?
Yes, sir.
The guilty plea is accepted. There will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. You understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial. Do you understand that?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, Your Honor.
How do you wish to plead to the charge that on about March 17th of 2022 in the village of Blissville in the county of Lenawee, that you did commit the offense of child abuse second degree, guilty or not guilty? Has anyone made any threats or promises to you to induce you to plead guilty to this charge? Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your choice to enter the plea? Right, and you just speak up a little bit,
Yes,
right? Okay. Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Hartung?
No, Your Honor.
Mr. Mawad?
No, Your Honor.
Has your attorney promised you any particular sentence or estimated what your sentence will be?
No, Your Honor.
Is it your own choice to plead guilty?
Yes, Your Honor.
Okay, so Mr. Mawad, do you wish to lodge your client and get the factual basis on the record?
I can, and Mr. Hartug can, if I miss something, can obviously ask her some questions. Bailey, on the date and time stated in the complaint in the county of Lenawee, you were with some kids, right? You were babysitting or you were watching some kids, is that correct?
Yes.
And what is the initials of the child, the initials only of the child that's involved in this case?
JS.
All right. And you were watching JS, is that correct?
Yes.
At some point in time, there was some frustration, anxiety, I don't know what you want to call it, but you got mad at JS and you used your right hand or your left hand and you hit him, as you admitted in the police report, very hard in the face, the side of the face, hitting the ear and the eye. Is that correct?
Yes.
All right. And you understand that this child went and has received treatment at the hospital for various issues concerning his eye and his ears, correct?
Yes.
I'm going to let Mr. Hartung ask any questions that I obviously did not finish, but Mr. Hartung is to your left, I think, or yeah.
Mr. Manske, the child in question was the son of your then fiance, is that correct?
He was not my fiance, he was
Just a boyfriend at that point in time, okay. And you had babysat for this child previously.
Yes.
At the time of this incident, the child was 3 years old, is that correct?
Yes.
And you were aware that as a result of the striking, he received hospital treatment, is that correct? And he suffered injury to his skull and the area around his eyes, the orbital area around his eyes. You became aware of that. And you took him to the doctor, I believe, the next day or the next morning. And the doctors commented as how misshapen his head had become due to this injury. You recall that?
We all have a doctor here right now.
Doctors surmised he had suffered a closed head injury. You recall that?
Yes, speak up first, okay?
Yes.
Again, I'm going to put this word on the record so we have it here, and I continue to mispronounce this. I'm sorry, Your Honor. But one of the things that he was diagnosed with was bilateral periorbital ecchymosis. Did you become aware of that at some point in time?
No.
I have no further questions. Thank you.
Ms. Adams, could we get Mr. Dietos next? Mr. Mawad, any further questions for your client?
No, Your Honor. I appreciate it.
Has the court complied with MCR 6.302 B, C, and D? Mr. Hartung?
Yes, Your Honor.
Mr. Mawad?
Yes.
All right, I accept the plea has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He or she does. She does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. Mr. Mawad, are you available on June 29 at 8:15 for sentencing?
Judge, I start a CSC trial in Wayne County on that day.
How long will that trial last?
Well, I think it's gonna go a week and a half because you have 404B witnesses coming in, 2 of them. So I honestly, a week to week and a half.
All right, Ms. Adams, July 20 or 21 available for sentencing?
Not that week, Judge, I'm sorry.
Okay, when would be the next available time for sentencing?
We could do July 27th.
Sure.
2/7, July 27, Mr. Mawad?
Sure, Judge.
All right, so I will set this for sentencing on July 27 at
And I'll-
8:15 in the morning.
I'll be
Now,
there in
Mr.
person, Judge. I'll be there in person.
Okay, I was gonna set this in person, so Mr. Manske, I'm going to send you across the hall to the Michigan Department of Corrections office right there.
Okay.
You're just gonna check in. They're gonna give you a packet to fill out and set up a time for you to meet with the probation department. Make sure you meet with them. When you meet with them, be truthful about your background, the events that occurred. And we'll see you back here for sentencing on July 27th at 8:15 in person.
I missed
Any
the
questions?
offense date.
The offense date was March 17 of 2022, Village of Blissfield, County of Lenawee.
Thank you.
You're welcome. All right, so we'll see you back on that day.
Thank you. Thank you, Bailey. Thank you, Doug.
Thank you,
Appreciate it.
Mr.
Bye, guys.
Thank you, Mr. Mawad.
Thank you, Mr. Mawad. All right, so, let me get, where's he at? All right, Mr. Spearman, hold on. We'll get your file. Do you have one more?
I was gonna sit in on Mr. Diettos if you're going to do that, but.
He's
I
not,
think
he's not
that's
waiting for him from the
Mr.
jail.
Wise's case, actually, just helping out.
Let me see if he's.
Your Honor.
Yeah.
On Diethos, there, I talked to Jackie last night, kind of late, and so I haven't had a chance. She says she has a pretrial on Friday. Could we adjourn this over to the same day as that?
She says who has a free trial?
She said she has a pretrial in front of you on Friday. And because I told her I needed to adjourn it like a day or two, and she asked, or I was wondering if we could adjourn it to the same day as her other pretrial.
Miss Adams, do I have a criminal pretrial on Friday?
Judge, I can jump in. We set Christopher Mauer for Friday at 11.
Do you want me to set this one at the same time?
Yes, please.
Yes, Your Honor.
All right, so Miss Adams, okay, so we won't take Mr. Diethos this morning. We'll set him for a pretrial on 5/12 at 11. Okay, thank you.
Thank you very much,
All right.
Your Honor.
You're welcome. Okay, so Mr. Spearman, thank you for your patience this morning. So this is in the matter of the people of the state of Michigan versus Terrence Ray, Malik Spearman, file number 23-21348FH. I have Rhonda Underwood appearing on behalf of Mr. Spearman, and I have Isaac Sneed appearing on behalf of the people. This is the date and time set for arraignment in this matter. Ms. Underwood, do you waive the reading of the felony information?
We would waive reading of the felony information, Your Honor, acknowledge its receipt and the receipt of the witness list and request for discovery, Your Honor. We would ask the court to enter a not guilty plea on Mr. Spearman's behalf and set this for probably a pretty expeditious pretrial.
All right, my next available pretrial is June 14. June 14 at 8:30 in the morning. So I will enter a plea of not guilty on behalf of Mr. Spearman. We will set a pretrial for June 14 at 8:30 in the morning. Mr. Spearman, has a plea offer been made to you, Ms. Underwood?
I'm sorry,
Was a plea offer made or no?
the plea offer at this time is as charged, no supplements, Your Honor. Mr. Spearman is a habitual third.
Okay, all right, so the maximum penalty on these is 5 years. With a habitual third offense notice, it could be a maximum penalty of up to 10 years. All right, and very good. So Mr. Spearman, we will see you back on June 14 at 8:30 in the morning, all right?
Okay, thank you.
All right, thank you, Mr. Spearman. Have a good day.
You too.
Thank you,
All
Your
right.
Honor.
Okay, so from the jail, do I have Mr. Diethos?
Yes.
Mr. Diethos, your attorney and the prosecutor popped in and they asked for this to be set for Friday at 11 a.m. So I set this over to Friday at 11 a.m. and we'll have you back at that time, all right?
Okay.
All right, thank you, Mr. Diethos. If you could let them know that I would like, let's see, Mr. Walker next, that would be great.
All right.
All right, thank you. All right, okay, so Ms. Hennigan, you were next, and then I have Mr. Sala. Could you represent again?
Yes, my client is in the hall. I can bring her in when you're ready, but Mr. Fleming was on this case.
Who's your client?
Ms. McGrath.
Ms. McGrath. All right, we'll get your client. There she is. All right, I have a gentleman on a Samsung. I'm going to send you a request to unmute your device. All right. Oh, you're laying down. Why don't y'all sit up? Sit up. There you go. What is your name? I'm going to ask you to unmute. Yep, what's your name? Say it again.
Tyndall.
I'm sorry, I kept talking over you. I'm so sorry.
Tyndall.
Yep, I got it. I got it. So give me just a second, and Mr. Murphy is your attorney, and I think, all right. So Mr. Tyndall, I'm going to change your screen name so I know who you are. And Mr. Murphy is your attorney. So I'm going to change your screen name and I'm going to pop you in the waiting room and I'll bring you back in a few minutes. All right. This
Your Honor, can I pop over to Mr. Judge Olsaber's court? He's got someone in person that he wants.
Okay.
I'll be right back.
That's what they always say and they never do it, but you're more than welcome to go. All right. Okay, so now I have Ms. Hennigan and let's see here. All right, so this,
Your Honor.
this is in the matter of the people of the state of Michigan versus Cheryl Lynn McGrath, file number 22-21044FH. I have Christopher Fleming appearing on behalf of the people, and I have Tamaris Hennigan. Are you appearing on her behalf or on behalf of Mr. Daly on her behalf?
I'm appearing on her behalf, Your Honor. I filed a substitution.
Okay, so I'm gonna write your name in.
Thank you, Your Honor.
You're welcome.
We haven't received a substitution yet. Have you received all the discovery from Mr. Daly?
I have received, I believe I have everything, Mr. Fleming. They put it on zip drives and everything for us, so I believe I have the full file.
Perfect.
Okay, so this is the date and time set for pretrial. We are scheduled for trial on May 23rd at 9 a.m. Are you ready to go to trial?
We are not, Your Honor. Mr. Fleming and I've been chatting this morning. He said he does not have an objection to adjourning the trial if the court will allow. He's also provided me with an offer this morning that I hope to be able to discuss with Ms. McGrath later today. It'll kind of be a lot for the process, but we'll speak about it. So we are asking for the trial to be adjourned out.
Okay, so This is a felonious assault with a tractor which carries a maximum penalty of up to 4 years, as well as a 5-year. Has a plea offer been made?
This morning, yes, Mr. Fleming did make an offer to me. I
Okay.
have not had opportunity to discuss that offer yet.
All right, so I will take the trial off the docket. And you want just a pretrial?
Yes, could we get a new pretrial, Your Honor?
No trial date, just a pretrial?
Yes.
Okay. All right, so I will set this for June 14 at 8:30 in the morning. Are you available that day?
The
Yeah,
people
Your
are,
Honor, I have another.
Okay,
pretrial that day.
June 21 at 8:30 in the morning?
Yes.
All right, so I will set another pretrial for June 21 at 8:30 in the morning. You've already filed your appearance?
Yes, Your Honor. I have.
Okay. So,
Mr. Fleming, I'll make sure that another copy comes over to you of the substitution.
okay,
Perfect.
and then
Thank you,
if
Ms.
you
Eddie.
could do a stipulation in order to adjourn the pretrial.
Yes,
Mr.
Your Honor.
Fleming, can she sign your name with permission?
absolutely, Judge.
All right, so ma'am, we'll see you back on that day, and anything else, Ms. Hennigan?
No, thank you, Your Honor.
All right, very good, thank you all.
Congratulations on your horse.
Okay, so, who do I have from the jail?
My name is Richard Walker.
All right, so the room's pretty wonky in there, so, for sound, so if you could scoot up a little bit, and, you're Mr. Walker?
Yes.
Okay, all right, so Mr. Sala, is your client with you, Mr. Sala?
Yes, Your Honor. He is here with me.
Okay, excellent. All right, and Miss Adams, Miss Holly had been put in a breakout room with Mr. Amadeo's client, and something happened. Could you perhaps email Mr. Amadeo and have his client contact MDOC?
Actually, I think it was Michael's and he called the office.
Oh, never mind.
So we're
Okay,
good. Thank you. Thank you.
Okay. All right, let me get your file, Mr. Sala, there we go. All right, this is in the matter of the people of the state of Michigan versus Pedro Hernandez, file number 2023-21325FH. I have Stanley Sala appearing on behalf of Mr. Hernandez, who is present in his office, and I have Prosecutor Sneed appearing on behalf of the people. So, Mr. Sala, this is the date and time set for pretrial. How do you wish to proceed today, sir?
Well, I haven't had an opportunity to talk to the prosecutor regarding any possible resolution as of yet. So I understand, is this Mr. Sneed's case then at this point? Does he have authority to discuss any potential resolution?
So on Wednesdays, I don't break out rooms. You and Mr. Sneed can talk via telephone, text, or chat, but
Yeah, that's fine. I just need to know
Okay.
who to talk to.
Mr. Sneed, is this your case?
What's the name of the case, Judge?
Pedro Hernandez?
1 second, I can look it up.
That is actually my case, Judge.
Okay.
Okay. Are you able to talk, well, I've got Mr. Sneed. Are you able to talk to Mr. Sala while I take care of another case?
Of course, Judge.
All right, so Mr. Sala, I'm gonna put you in a breakout room with Mr. Fleming and see if you can. And I don't know if Mr. Fleming wants your client in the room or not, but that's
I'll
up to
have,
you guys,
I'll
right?
have stuff.
Join the breakout room and you're all set. All right.
Step out.
So, Mr. Walker, your attorney is. So. Your attorney is Miranda Underwood, and she just went down to Judge Bolsaver's. So I have lots of prosecutors, but no defense attorneys. So I'm gonna let my staff take a brief recess, and I'll be back in just a minute.
Excuse me. Yes, sir.
Do I need to check in because with the clerk's office before I?
No.
I've been here.
Yeah, what's your case?
My name is Jason Wright. I got,
Who's your attorney? I'll say something. Yeah.
I mean, my name was on the board.
If you take a look at our docket,
It's pretty full.
8:15, no, 8:15 has about 10 people all the way to 8:30, and 8:30 has about another 10. Actually, there's about 15 people. All the way
I just
to
wanted to
9
make sure I
o'clock.
didn't have to check in or something.
Yeah. No, you're fine. She'll get there and Rhonda will also go through. So,
Thank you very much.
all right.
I'm back.
Hi. You know, I was here last week. I was gonna drop off some, I have a trial with the judge on the 30th, but by the 19th, that, the trial will be done. I came in that one day and I was gonna, and she said, well, you gotta finish up the stuff. So I'm just giving you a copy of the exhibit list, right?
That's fine.
Yeah. Exhibit, those are attached to the trial brief and give it to the judge.
Yeah, you need to, yeah, you need to file the original evidence or whatever. I don't know. Ask the clerk something about that, because I usually don't get the exhibit. I'll help you mark them if you need stickers.
I got stickers.
Okay.
I've already marked them. Everything's ready to go.
You can send me the list and your witness list. My email. I can give you my email.
Sure. I was gonna drop by over the next couple of days anyway, so.
Okay, well, if you want, you can just, that way you can send it to Becky, whoever, that way the judge gets it.
Yeah. Thank you.
And your, for sure, your witness list, is that filed already?
Oh, yeah.
Yeah. Okay.
Everything's fine. Yeah. We're trying to settle it. I think we're close. So.
Okay.
Thank you.
All right.
Just remember, we're live on YouTube. So, Mr. Trushan, are you coming in on Tyndall?
I am not, Your Honor. I see that is Dawn Van Dusen.
Okay, I had it go from Matt Murphy. Okay, so let's see, Mr. Sala, hold on. So George Trushan, you're here on Randy Kiefer, Blake Barton. And is that it?
Timothy Merritt.
Merritt. Okay, give me just a moment. Miss Adams, after I am done with the gentleman in the jail, I'll take Mr. Merritt next.
Okay.
All right, Mr. Sala.
Yes, Your
We
Honor.
are back on the record in the matter of the people of the state of Michigan versus Pedro Hernandez. Have you had enough time to speak with Mr. Fleming?
I have, Your Honor. We've agreed to adjourn this pretrial and get some more information regarding this case.
Okay, how far out would you like an adjournment?
30 days.
And so, perfect. How about June 14? At 8:30, are you available that day?
Yes.
All right, so Mr. Sala and Mr. Hernandez, I will adjourn this to June 14 at 8:30 in the morning. And Mr. Sala, you can do the stipulation in order to adjourn. And Mr. Fleming, can you sign your name with permission?
Yes, Judge, thank you.
Thank you, Your Honor.
Thank you. All right. All right. Yep. Blake Barton, right? Blake Barton. So what is your name? Are you guys Jason Wright? Who's your attorney?
Miss Underwood.
Okay, she'll be back. All right, I'll bring in Mr. Barton. Well, all right. Let's get it connected to audio. Right, he's connecting, it looks like. All right, Mr. Barton, can you hear me?
Yeah.
All right, this is in the matter of the people of the state of Michigan versus Blake Anthony William Barton, file number 23-21272FH. We have George Truchon appearing on behalf of Mr. Barton today, and I have Alexander Bayonetto appearing on behalf of the people. This is the date and time set for pretrial. So I see the plea offer in this matter was plead as charged to count 1, which is a 5-year. This is the date and time set for pretrial. So Mr. Truchon, how do you want to proceed today?
Your Honor, if I can ask the court a few questions. Obviously, this is a first impression for me. I'm just filling in for Mr. Murphy today.
Yes, sir.
I see this is a third offense OWI case, and you're indicating there has been no offers other than plead as charged.
So, so I have Mr. Bayonetto, correct me if I'm wrong, I have as charged count 1, 5-year felony. So if he were to plead to count 1, operating while intoxicated, which is 3rd year with a 3rd offense felony notice, it's a 5-year felony. Count 2, as well as his habitual offender, would be dismissed. Is that correct, Mr. Bayonetto?
That's correct, Your Honor, yes.
Okay. So the count 2 driver's license suspended, which is a misdemeanor, would be dismissed, as well as the habitual offender 2nd offense notice. So instead of a 7.5-year felony, it would remain a 5-year.
I understand. Right now, as it sits today, Your Honor, I would ask that in fact, Mr. Murphy's been dealing with this, and because there's not much of a reduction in regard to the 3rd offense, I would want Mr. Barton to have the opportunity to speak with Mr. Murphy about an absolute resolution in regard to this. So I would ask in the court's deference if you could set this over just for a short time. Mr. Murphy is back Monday, Your Honor.
Okay. So my next available is June 21. So Mr. Barton, I will set this over for another pretrial on June 21 at 8:30 in the morning, and that'll be via Zoom, same number you called today, and I'll continue your bond conditions as well as your not guilty plea. All right?
Okay, one question I do have, I've been talking with Darren Coates, the pretrial service guy. He said to bring up in my court case today, as I was put on the alcohol tether because I was letting my sober link die too many times. I was just wondering if there was any way I could get put back on that sober link. I'll make sure it stays charged. It's just, I'm a single father. I'm a full-time dad, and I can't afford the extra $35 a week right now. On top of everything else, if I could get put back on the sober link, the normal breathalyzer, that thing's like $35 cheaper than what they have me on now. It would help me out majorly.
All right, Miss Adams. Miss Adams, could you have Mr. Coast zoom in?
Judge, he's not available today. I'm sorry.
Okay, so I'm gonna guess that I didn't do the order switching over. So because that was at his discretion per your discussions with him.
Yeah, he did, because I just kept letting it.
Okay, so I'm going to speak with Mr. Coast.
Okay.
And see if we can do that. And if we can, I'll let you know, all right?
Awesome, I appreciate it. But thank you very much, Your Honor.
Anything else, Mr. Truchon?
Nothing further, Your Honor. Appreciate the indulgence.
Yeah, and let me make this note. You want it back on sober link?
Yes, the breathalyzer, the twice a day that I was originally on.
All right, I've got a Post-it note there, so I will remember. And we'll see you back then on your next pretrial on June 21 at 8:30. So thank you, Mr. Barton.
Okay, thank you. I'm writing that down right now. I appreciate it, Your Honor, and have a wonderful day.
You too.
Bye-bye.
Randy Kiefer, you're on Kiefer, right?
I am, Your Honor.
So I haven't seen Mr. Kiefer this morning. He's not logged in, and he has not shown up. So, Nowicki and hold on. Okay, so we have all right, in the matter of the people of the state of Michigan versus Randy Kiefer, file number 2023-21302FH. I have George Truchon appearing on behalf of Mr. Kiefer, and I have Isaac Steen appearing on behalf of the people. So Mr. Truchon, Mr. Kiefer is neither in my waiting room, the jail, or in the courtroom, but I do have an active bench warrant that was filed on April 21 of 23. Mr. Kiefer failed to drug test on April 10, April 14, and April 18. At this time, he has missed 6 consecutive screens, but tested positive on April 7. He does have an active bench warrant, and he has failed to appear. So I will also issue a bench warrant on the file itself for failure to appear and set bond in the amount of $75,000 cash. He is charged with possession of a loaded firearm and delivery manufacturing. So if you're able to reach him, we would love to see him.
I will go right after being with you, Your Honor, in regard to this, go right to the office and make them aware of proper notifications.
Now, who else do you have?
The only other one I have, Your Honor, is a Timothy Merritt.
Right, and Mr. Merritt's at the jail. So, Mr. Walker, I do apologize. Your attorney said she was going next door for 1 minute, and it never is just one moment. So could you ask them if I could switch you out for Mr. Merritt, and then I'll bring you back in after Mr. Merritt? I appreciate that. So give us just a minute. Sir, do you want to come up to the podium? I've got this under. Waiting for the jail. I'm sorry, Mr. Trushan. I am down to just people at the jail now, so it takes a minute. All right. Miss Underwood, Mr. Wright is here. So do you mind if we take care of Mr. Wright first?
I'm sorry?
I have Jason Wright. So.
Great.
Great. So this is in the matter of the people of the state of Michigan versus Jason Scott Wright, file number 2022-21032FH. And Rhonda Underwood appearing on behalf of Mr. Wright, and I have Isaac Sneed appearing on behalf of the people. This is the date and a half, the date scheduled for pretrial. I will quash the April 26th of 2023 bench warrant. He did reach out to you and he did appear today. So Ms. Underwood, how would you like to proceed on the pretrial?
Your Honor, I believe I spoke to Mr. Wendt, and I believe Mr. Wright made a payment, and Mr. Wendt would have no objection to having him complete diversion in this matter, Your Honor. So I believe perhaps a pretrial in the first part of June to see where we are on that, Your Honor.
All right. So, Mr. Wright, just a reminder, the economic diversion program is a really good program to try to resolve this. So, Ms. Adams, I'm going to set this over to June 21 for a pretrial. Could I get a notice of hearing to serve Mr. Wright with today? So June 21 at 8:30 in the morning. And have a seat right there and we'll get you a notice, okay?
Yes, Your Honor, I think the only thing I have left in that diversion program to do is a letter that I have right here and finish up my classes, which I have an assessment for my classes today.
Good. All right, good. All right.
That's June 21st, Your Honor.
Yes, ma'am.
And the court is doing the notices?
Yes, because he's here and I want to give him a notice in person. All right, I have Mr. Nowicki.
Excuse me, Your Honor. Would that be, is that gonna be Zoom or do I come in for that one too?
Say it again.
Would that be on Zoom or what?
Zoom.
Okay.
Okay.
Sorry.
Zoom. Or in person, you can do either, it doesn't matter. All right, Mr. Nowicki, go ahead and unmute your device, please.
Okay.
All right, this is in the matter of the people of the state of Michigan versus Brandon Kennedy Nowicki. And this is file number 23-21244FH. I have Rhonda Underwood appearing on behalf of Mr. Nowicki. And I have Isaac Sneed appearing on behalf of the people. This is a date and time set for pretrial. Ms. Underwood, how do you wish to proceed with Mr. Nowicki?
Your Honor, I've had some discussions with Mr. Sneed regarding this matter. The current offer, as I understand it, is an attempted resisting and obstructing with no objection to its 771 determination, Your Honor. And Mr. Nowicki is also being sentenced downstairs on a on a assault and battery matter. Your Honor, Mr. Nowicki is in an AFC home on the west side of the state doing very well. So if I could just speak with Mr. Nowicki for a minute, maybe we'll see.
All right, Mr. Nowicki, I'm gonna put you in a breakout room with Miss Underwood.
Okay.
And I want you to click on join, and when you're done speaking with Miss Underwood, I want you to either stay there or come back. You can leave the breakout room, but not the meeting, all right?
Okay.
Mr. Hartson, hold on one second. All right, Miss Underwood, let me bring, oh, your client's back. So Miss Underwood, how would you like to proceed with Mr. Nowicki?
I believe my client has decided that they do wish to avail themselves of that offer, Your Honor. So I believe a amended will be necessary.
So what did you say he was gonna, how old is your client? How old are you, Mr. Nowicki? How old are you?
I'm 27. I'm going to be 28 at the end of the month.
Mr. Sneed, what's the cutoff date for HIDA now with permission?
Thought it was 26, Judge.
Okay. Okay, okay. All right, and Ms. Underwood, you said the plea would be under what?
I believe it was, hang on. The delay statute.
Delayed sentence, is that correct, Mr. Sneed? A delayed?
Yes, 771.1, Judge, and just to clarify, the HIDA cutoff is 25.
Okay, all right. Okay, so he's going to plead to an added count 2 attempted resisting and obstructing a police officer under a delayed sentence. Is that correct, Ms. Underwood?
That's correct, Your Honor.
Mr. Sneed, you'll get us the amended information today.
Yes, sir.
Thank you. All right, so Mr. Nowicki, you want to raise your right hand for me?
Yep.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, good. You can put your hand down. Miss Adams, could you remind the jail I would like to have Mr. Walker, please? All right, so Mr. Nowicki, can you state your full name on the record for me?
Brandon Kennedy Nowicki.
All right, so Mr. Nowicki, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to an added count 2 attempted police officer assaulting, resisting, and obstructing, which carries a maximum penalty of up to 1 year in jail and up to $1,000 fine? So is it your intention to plead guilty to that count?
Yes.
Are you satisfied with Ms. Underwood as your attorney and the advice that she has given you?
Yes, I am, Your Honor.
Okay, neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed any possible sentence with the court other than the delayed. Is that correct, Ms. Underwood?
It is correct, Your Honor.
Is that correct, Mr. Trush, or I'm looking at Mr. Trushon. Is that correct, Mr. Sneed?
Yes, it is, Your Honor. Thank you.
Okay, and Mr. Nowicki, is that correct as far as you're aware?
Yes.
Okay. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Nowicki?
Yes, I do, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, I do, Your Honor.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. So do you have any questions about the rights that I've given to you?
No.
All right. Mr. Nowicki. All right. Mr. Merritt, I'll be with you in just a moment, okay? Okay. So, Mr. Nowicki, how do you wish to plead to the charge that on or about November 25 of 2022 in the city of Adrian, the county of Lenawee, that you did commit the offense of attempted police officer assaulting, resisting, and obstructing? Guilty or not guilty?
Guilty, Your Honor.
All right. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
Your Honor.
Okay. Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, I do, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Underwood?
No, Your Honor.
Mr. Sneed?
No, Your Honor.
All right, has your attorney promised you any particular sentence or estimated what your sentence will be, Mr. Nowicki?
No, Your Honor.
Okay. Is it your own choice to plead guilty?
Yes, it is.
All right, so Mr. Nowicki, on November 25 of 2022, were you in the city of Adrian in the county of Lenawee?
I was.
And at that time, did you come in contact with an Adrian police officer who the police report named as Sergeant Payne?
I did, Your Honor.
Was it daytime or nighttime when you met up with him?
It was daytime.
Okay, and were you walking down the street? Were you at your house? Where were you?
I had actually spent the prior night sleeping outside underneath a street lamp.
Okay, and was that downtown?
No, it was outside of town.
Okay, and so, and when did you come in contact with Mr. or Sergeant Payne?
When they had taken me to the homeless shelter.
Okay, so they picked you up where you were sleeping outside and they were taking you to the homeless shelter?
Yep.
Okay, and at some point, did you try to run away from them? Did you resist, like Ms. Underwood, perhaps you could help me a little bit with what the offense is?
Brandon, did you try to jerk away from them or get something away from them?
So what had happened was I had 3 backpacks with me and I was getting trespassed from Share the Warmth, the homeless shelter. And so when I reached down to grab my 3 backpacks, I put out one hand as counterweight and he viewed that as assault on him. Is my understanding.
Mr. Sneed, is there any objection to changing this to a no contest plea?
I have no objection to that.
All right, Mr. Nowicki and Ms. Underwood, would you like to change this plea to a no contest plea?
That's fine, Your Honor.
All right, Mr. Nowicki, would you like to withdraw your guilty plea and change it to a no contest plea and allow Ms. Underwood to place the factual basis for the offense on the record?
Yes, Your Honor.
All right, so I'm going to ask you again, Mr. Nowicki, how do you wish to plead to the charge that on or about November 25, 2022, in the city of Adrian in the county of Lenawee, that you did commit the offense of attempted police officer assaulting, resisting, and obstructing? And if you'd like, you can say no contest.
No contest.
All right, Ms. Underwood, would you like to place the factual basis for the plea on the record, please?
Yes, Your Honor. I'm reading from the police report of that date, Your Honor. And he appeared he was going to walk back to the side of Share the Warmth. As he took a few steps towards me, he dropped his left shoulder and then lunged into me, hitting me with his shoulder on my chest. I then took his arm and ordered him on the ground. He pulled away a bit and I pulled him to the ground by the arm. I believe that's sufficient, Your Honor.
All right, Mr. Sneed, any additions?
I'd just like to add that narrative is by Sergeant Payne from the City of Adrian Police.
Okay, and from the police report regarding this incident. All right, all right, so based on the facts placed on the record and from the information contained in the police report from the statement of Sergeant Payne, the court finds beyond a reasonable doubt that on or about November 25 of 2022 in the city of Adrian in the county of Lenawee, that the defendant did commit the offense of attempted police officer assaulting, resisting, and obstructing by striking Sergeant Payne in the chest area, and therefore the court accepts the no contest plea. So what I'm going to do, Mr. Nowicki, is, well, hold on a second. Has the court complied with the MCR 6.302 B, C, and D, Ms. Underwood?
It has, Your Honor.
And Mr. Sneed?
Yes, Your Honor.
All right, let's see. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. This plea will be taken as delayed. So what I'm going to do is refer this matter to the Michigan Department of Corrections for a pre-sentence investigation. Ms. Holly? Mr. Nowicki is in AFC home in Western Michigan, so he won't be able to travel in person.
Okay.
So we'll have to set it up either phone or Zoom, but I'll put you in a breakout room with Miss Holly, Mr. Nowicki. And
Okay.
when you meet with them, be truthful about your background, the events that occurred, and then Miss Holly will have someone from the Michigan Department of Corrections prepare a pre-sentence report. We'll have Ms. Underwood get a copy of that. She'll review it with you. I'm going to set your sentencing out quite a bit. So Ms. Adams, I'm looking for a November sentencing date, Ms. Adams.
Okay. November 9th at 8:15.
All right, so I'm going to set sentencing for November 9th at 8:15 in the morning, Mr. Nowicki. Ms. Holly, when you speak with him and you get his address, could you give that to Ms. Adams too?
Okay.
Okay, So Mr. Nowicki, I'm gonna put you in a breakout room for you to speak to Miss Holly. Make sure you follow all her instructions, and we will see you, Miss Underwood. You're gonna get like a breakout room invitation. Don't go there. So Miss Holly, let's see.
Judge, are we gonna schedule that via Zoom as well?
Yeah. So Mr. Nowicki, do you have any objection to appearing via Zoom for your sentencing?
I do that.
Okay, so we'll have you appear via Zoom. All right, go ahead and join that breakout room. All right, Miss Underwood, I'm gonna take care of Mr. Trusham real quick because I have Mr. Merritt. So, hold on, let me find them. And Miss Adams, once you get that address from Miss Holly, could we send a notice of hearing to him at the AFC home, because they might need that.
Okay.
Merritt. All right, this is in the matter of the people of the state of Michigan versus Timothy Joe Merritt, file number 20-20099FH. I have George Trushon appearing on behalf of Mr. Merritt, who's appearing from the jail, and I have Isaac Sneed appearing on behalf of the people. This is the date and time set for, looks like this is about contempt of court. Oh, it looks like this is, hold on. So we have contempt of court for extended bond. Hold on. Contempt of courts. I'm trying to see if he actually must have. Okay. It said rearrangement, but I want to make sure. So it looks like this is the date and time set for a pretrial and contempt of court hearing. So, no, this must be a bond. Ms. Adams, is this a violation of probation, or is this an underlying? No, it looks like you. It looks like it was never. Okay, so this is quite an old file, but it looks like this is actually just a pretrial and a contempt of court pretrial. I'm sorry, Mr. Trushon. So, Mr. Trushon, how would you like to proceed today on behalf of Mr. Merritt?
If I could ask the court, Your Honor, again, I come in fairly cold from Mr. Murphy from the Public Defender's Office. I see that the underlying charge of this, I believe anyway, from my notes, are assault with a dangerous weapon on a police officer. And where are you at with that so far? That's not been adjudicated?
No, that's why I thought it was a bot, because it's such an old file, but he appeared at arraignment and it looks like a plea was never entered. Wait, what's this? What is this? Matt Murphy. They did a bail reduction. I released him on bond, and then it looks like he didn't appear. So he's charged with 1 4-year felony, felonious assault, 1 2-year police officer R&O. This is a 4th offense notice. So he could be looking at a maximum penalty of 8 years on count 1 and 4 on count 2. And it looks like it's never been resolved, either contempt of court. So you probably want me to set this over to a pretrial for Mr. Murphy to talk to him?
I would think so, Your Honor. See if in fact there's any movement for the prosecutor's office or when he talks to Mr. Merritt where they're at with this. So if you could set this over for a pretrial, and I will notify Mr. Murphy that the contempt may also take place at that time.
Okay. So, Mr. Merritt, what I'm going to do is continue your not guilty plea, and I'm going to set this over to May 31 at 8:30 in the morning for another pretrial, and then the public defender's office will do the stipend order to adjourn, Mr. Trushon. So,
I will notify them today.
all right, so May 31 at 8:30 in the morning for another pretrial, and Mr. Sneed can, Mr. Trushon, have your name signed with permission.
Yes, please.
Okay, all right, so Mr. Merritt, we'll see you back on May 31 at 8:30, okay? right, I have one more file that is Mr. Murphy's today,
Oh, you are?
and
Okay.
it's Cavani Tyndall. Right now.
And I received a call, just to let the court know, from the public defender's office yesterday.
That would be mine, George.
Oh, Ms. Van Dusen's there. Okay. I think you're all set. Thank you, Mr.
Thank you,
Tushan. Mr. Nowicki, you are all set and you can go on your way and have a good day.
Thank you. Have a good one.
All right, thank you. All right, I'm sorry, Ms. Van Dusen, I forgot you had popped in. Okay.
That's okay.
All right, so Ms. Adams, I guess from the jail, Ms. Underwood, can we get Mr. Walker for Ms. Underwood? Okay, and then it looks like the rest are Dawn's and Sam's. Okay. Mr. Tyndall. All right. So this is in the matter of the people of the state of Michigan versus Cavani Tyndall, file number 21-20422FH. I have Brenda Underwood. No, I don't. I have Dawn Van Dusen appearing on behalf of Mr. Tyndall. And I have, Alexander Bandetto, I guess I'm going to go with, appearing on behalf of the people. I have some notes. So is the plea to count one with no subs still available or no?
Yes, Your Honor, with a Killebrew and no upfront jail. And
Right,
he's going
is
to
it
take the
count?
plea.
Hold on, is it count one second offense or just count one?
Just count one, Your Honor. No
So it'd be a
second.
4-year felony?
Yes, Your Honor.
Okay, so the plea offers plea to count one, which is a 4-year felony. Count the second offense notice as well as the habitual offender 4th offense notice would be dismissed. And what did you say else, Ms. Van Dusen?
Killebrew to no upfront jail.
Okay, so, okay, so Mr. Walker, hold on a second. Ms. Underwood, do you need a breakout room with Mr. Walker?
I believe Mr. Walker, Your Honor, has matters in.
No, I asked if you needed a breakout room.
Yeah, just briefly. Yeah. That makes
Okay.
sense.
I didn't call the case yet. I just was gonna give you a breakout room while I was taking care of this. All right, I'm gonna send you both to a breakout room. Mr. Walker, use the mouse to join the breakout room. All right, and Mr. Bandetto, is that a correct recitation of the plea?
It is, Your Honor, yes.
All right, so Mr. Tyndall, can you raise your right hand for me, please?
Yeah.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yeah.
All right, so Mr. Tyndall, could you state your full name for the record?
Cavani Montez Tyndall.
All right, so Mr. Tyndall, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count one, controlled substance, possession of cocaine with under less than 25 grams, which carries a maximum penalty of up to 4 years in prison and or a $25,000 fine? Does this still carry license sanctions or is this an old information? Mr. Bandetto and Ms. Van Dusen, do you know?
I don't
I was
remember.
told that it was old, that it was nothing that's gonna be, no, that it was all old, that it was, that I won't.
Hold on, Mr. Tyndall, Mr. Tyndall, hold on 1 minute. I asked Mr. Bandetto and Ms. Van Dusen. Hold on 1 second.
I'm just saying because that's the plea that I was told before.
I know that, Mr. Tyndall, but if I don't get it on the record, it doesn't count. So that's why I was asking the attorneys, not you to
Understood.
place that on the record. Got it? All right, Mr. Bandetto and Ms. Van
That's on
Dusen.
record for me.
Well, it doesn't count if you say it. It only counts if they say it.
I know, but I'm just saying that's what I agreed
So
to.
are
I'm just
we
saying,
gonna argue? Because I can bring you back another day. Unless I say, Mr. Tyndall, don't talk. Let me get the record on so that it's a good record. So, Mr. Bandetto and Ms. Van Dusen.
I don't know the answer to that question, Your Honor. I can look into it. But off the top of my head right now, I don't know.
Well, I know it used to carry it, and this is a 21 file, so I was at Ms. Van Dusen.
That's where I have to look at the date on that. If you could just give me a second now, or if you can move on to the next one, we'll come right back to Mr. Tyndall.
Sure, sure, I can do that. All right, Mr. Tyndall, just hang on for a minute and we'll be back with you. I have the next one. Ms. Underwood, I'll bring the jail back and we'll take care of Mr. Walker. Right. Mr. Armstrong? Okay, all right. Mr. Barney should be here in a minute. Oh, come on up to the podium. Yeah, you just come up here. All right, so let me call this real quick. So this is in the matter of people of the state of Michigan versus Winshawn Earl Armstrong, file number 22-21058H. We typically have attorney Jerome Barney appearing for Mr. Armstrong. We have Isaac Sneed on behalf of the people. So, okay, so Mr. Barney is not here today. I do have a note from my pretrial services coordinator that pretty much the day we were last here, Mr. Armstrong did present him with the documentation that the court asked for. He completed his concealed pistol license course on June 25 of 22 and filled out the CPL application. The documentation was attached for me by Mr. Coast. So Mr. Sneed, I believe that was all the people were waiting for before they filed the nollie cross.
That's correct, Your Honor. Thank you for the update and thank you to Mr. Armstrong for providing that.
All right. So will the people file the nollie cross today then? And
yes.
Okay, so once that's filed, we'll mail a copy out to your attorney or to you, and then you should be able to carry on and get your CPL. All right.
Thank you.
You're welcome. All right, thank you
So
for
he
being.
doesn't have to come because he thought he had to do a Zoom, so he doesn't have to worry about that.
No, he's fine. Okay. All right, thank you.
We'll have a blessed day.
You as well too. All right, and Ms. Adams will make sure to mail a copy of the nollie cross to the council and Mr. Armstrong. Okay.
Can I ask one last question?
Sure.
Can I no, can I have this done to the word?
Back up here, I can barely hear you. I got this like plexiglass in front of me, and so I'm always like, what? I'll go ahead and say it again.
Make the word nully is it spelled N-U-L-L-Y?
I'll write it down for you. It's a weird word.
Okay.
Nollie cross just means a dismissal.
Okay.
That's all. Sometimes attorneys like to use big words to make them sound smarter than you really are. So, all right.
Thank you so much. I really appreciate you all.
Not a problem. Thank you, Mr. Armstrong.
Thank you for blessing.
Thank you. Okay, so Ms. Underwood, I have brought Mr. Parker back from the jail. So let me get his file, or Walker, I'm sorry, Mr. Walker. So this is hold on. Yeah, your bond will be returned. Okay. Yeah. Okay. Okay, so this is in the matter of the people of the state of Michigan versus Richard William Walker. We have three files, file number 20-20144FH, 21-20280FH, and 21-20281FH. And Rhonda Underwood appearing on behalf of Mr. Walker, and I don't need a prosecutor, I don't think, but I have one. So I have Isaac Sneed appearing on behalf of the people. So these are a violation of probation files. Miss Underwood, you've had an opportunity to speak with Mr. Walker.
Yes, Your Honor. Mr. Walker pled downstairs to a malicious use of telephone and a traffic offense, Your Honor. And those sentencings are scheduled for June 8th, I believe, with Ms. Zilke. So I believe Mr. Walker wishes to enter a plea at this time, Your Honor, to the violation.
Mr. Walker, you want to raise your right hand for me, please? All right. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, so I'm gonna need you to scoot forward a little bit and speak a little bit louder. So, Mr. Walker, can you state your full name for the record?
My name is Richard Walker.
Okay, all right. Your middle name is William?
Yes.
Okay, so Mr. Walker, you've heard the statement of your attorney. Is it your intention to plead guilty to the violation of probation charges today?
Yes.
All right. Now, Mr. Walker, you're currently on probation on 3 files. The allegations against you on each of those files is that you were arrested on or about January 4 of 2023 for stalking, and on December 29th of 2022 for reckless driving, and those charges were still pending. Do you understand those are the charges against you on each file?
Yes.
Okay, so on file number 20-20144FH, you're currently on probation for larceny 1,000 or more, but less than 20. So if you plead guilty or found guilty, the maximum penalty cannot be up to 5 years in prison. Do you understand that?
Yes.
And on file number 21-2028050, you're currently on probation for home invasion 2nd degree. So if you plead guilty or found guilty, the maximum penalty you could be facing, I have amended information somewhere, hold on, could be up to, hold on. Up to 15 years in prison. Do you understand that?
Your Honor.
Okay, and then on file number 21-20281FH, you're currently on probation for witnesses bribing, intimidating, or interfering, which carries a maximum penalty of up to 10 years in prison. Do you understand that?
Yes.
All right. Now, are you satisfied with Miss Underwood as your attorney and the advice that she has given you?
Yes.
Okay. Now, do you understand that you do have a right to contest the violation of probation charges and to have a trial on them? Do you understand that?
Yes.
You have a right to be presumed innocent until your guilt is proven by beyond a reasonable doubt. Do you understand that?
Yes.
You have a right to have all the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions, or you may ask them yourself, and to have me order any witnesses you might have to appear at the trial. Do you understand all of that?
Yes.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes.
On the other hand, do you understand that you have a right to testify at your trial if you want to testify?
Yes.
All right. How do you plead on each of these files to the charge that you violated the terms of your probation by being arrested on or about January 4 of 2023 for stalking, and on December 29 of 2022 for reckless driving? Guilty or not guilty?
Guilty.
Okay. Do you understand by pleading guilty, you'll be giving up your right to a trial?
Yes.
Has anything been promised you to get you to plead guilty?
Nope.
Has anyone threatened you in any way to get you to plead guilty?
Nope.
If I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes.
Is it your own choice to plead guilty?
Yes.
All right. So, Mr. Walker, you were placed on probation on each of these files, and one of the terms of your probation was not to commit any new crimes. Is that correct?
Yes.
All right. Now, Mr. Walker, on January 4 of 2023, were you arrested and charged with stalking?
Yeah, I turned myself in, and then they just PR bombed me. I didn't go to jail or nothing. So,
okay, but did you end up pleading to stalking or something else?
We pled to something else.
What'd you plead to?
It was like
interfering with telephone, Your Honor.
Is that right, Mr. Walker?
Yes. And
okay.
careless driving.
Okay. then you were arrested on December 29 of 22 for reckless driving, and they pled that down to careless. Is that correct?
Yes.
All right, and when are you set for sentencing?
The 8th of June.
Okay. All right, I accept the pleas. They've been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights, and he does have competent counsel. I am going to set this out for sentencing on May 16.
Did you say May 16, Your Honor?
Hold on. When are you being sentenced? June 8, you said?
Yes.
Okay, so Ms. Underwood, are you available May 16 at 8 o'clock?
May 16? I'm sorry, not May 16. I'm not, Your Honor.
Okay, Ms. Adams, I'm looking at the week of May 22nd.
Okay. So you have 8 scheduled and drug court on May 25th, but if you want to squeeze it in there.
What about May 23rd at 8?
You have another BOP sentencing and paternity hearings.
Do I have anything till 9 o'clock other than that?
Nope, just a jury trial at 9.
All right, so Miss Underwood, well, Ms. Adams, what about, you said May 25, what about May 26?
You are not available May 26.
May 30?
You are not available May 30.
Right, Miss Underwood, May 23rd at 8 a.m. Are you available?
I'm available, Your Honor.
All right, May 23rd of 23 at 8 a.m. Mr. Walker, do you have any objection to appearing via Zoom for sentencing?
No.
Okay. All right, so we will see you back May 23rd at 8 a.m. for sentencing via Zoom. Mr. Jones will do an update to your probation violation report. We'll get a copy of that to Ms. Underwood. She's really good about getting in and meet with people in advance. So we'll see you back on May 23rd at 8 a.m. for sentencing. Thank you.
Thank you, Your Honor.
All right, thank you, Mr. Walker. You're all set. Could you let them know I would like maybe Miss McKay or Mr. Reed next? All right, thank you. All right, so Ms. Van Duzen, back to Mr. Tyndall.
We do have an answer, Your Honor.
Good. All right, and what would the answer be on Mr. Tyndall?
There is no license sanction. In fact, if you read the 333.7408, it's regarding a juvenile.
Okay. All right, well. I don't have the statute in front of me, and I just looked at the felony information and it didn't say that, so I wanted to make sure. So Mr. Tyndall, the purpose of me doing that was just to verify on the record that statutorily there was not a license sanction. So do you understand, Mr. Tyndall? And you're muted, so you'll need to unmute yourself. Do you understand that there is no license sanction now?
Yeah, I understood that before. That's why I took it, but yeah.
And can we get an amended information for his file so that doesn't happen?
So Mr. Bayonetto, the felony information states that unless sentenced to more than 1 year in prison, the court shall impose license sanctions. So can we get an amended information so it doesn't say that?
Yes, Your Honor. I'll get it.
That way it doesn't get reported to lien. All right, so, all right, let me see here. I don't know where we stopped at, Mr. Tyndall. Try to check. All right, so if everybody cannot talk for 1 second, Ms. Applin's gonna go back and see where we stopped on Mr. Tyndall so we can resume.
About the Killabrew. So plea of count 1 4-year felony, second offense notice, habitual offense.
I can't hear you.
The last thing you talked about was Killabrew with no upfront jail. So it's plea to count 1.
Okay, okay, so,
Notices.
all right, so Mr. Tyndall, I swore you in already, and you're still under oath. So
Okay.
you've heard the complete statement of your attorney and the prosecuting attorney then. So it's going to be your intention to plead guilty to count 1, controlled substance, possession of cocaine, less than 25 grams, which carries a maximum penalty of up to 4 years in prison and or a $25,000 fine. And we did verify on the record that there would be no license sanctions. And wasn't there, what was the rest of the agreement, Ms. Van Dusen?
No upfront jail.
All right, and no upfront jail. So is it your intention to plead guilty to that, Mr. Tyndall?
Yes, ma'am. But I got a question though. Like, how long does a probation last on that? Or like, what is that? Or that be like decided as sentencing or like what?
Well, we give anywhere from 18 months to 3 years, and I'll decide that at sentencing.
Okay. All right. All right. Okay.
All right. And let's see. Okay. All right. So are you satisfied with Ms. Van Dusen as your attorney and the advice that she has given you?
Yes, ma'am.
All right. Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court other than the plea. Ms. Van Dusen?
That's correct.
Is that correct, Mr. Van Netto?
It is, Your Honor, yes.
And Mr. Tyndall, is that correct as far as you're aware?
Yes.
All right. Now, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, Mr. Tyndall, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, I do.
Do you understand that any appeal? Hold on 1 second. Mr. Malaro, do you need a breakout room with Mr. Hill?
Rodney Hill?
Yeah.
Is he in your courtroom? Oh, no, there he is.
No, he's on Zoom.
No, I don't need one, I don't think.
Okay. All right, Mr. Hill, I'll be with you in just a moment. All right, put you back in the waiting room, but you're up next. Okay. And Mr. Tyndall, do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that, Mr. Tyndall?
Right. Yes.
Right. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that are given to you?
No.
All right. So, Mr. Tyndall, how do you wish to plead to the charge that on or about October 19th of 2020 in the city of Adrian in the county of Lenawee that you did commit the offense of controlled substance, possession of cocaine less than 25 grams, guilty or not guilty?
Guilty.
All right. Has anyone made any threats or promises to you to induce you to plead guilty to this charge other than the agreement that was placed on the record?
No, ma'am.
Do you understand if I accept your plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Right. Yes.
Okay. Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Van Dusen,
No, Your Honor.
Mr. Bayonetti.
No, Your Honor.
All right, Mr. Tyndall, other than everything that was placed on the record, has your attorney promised you any particular sentence or estimated what your sentence will be?
No, but I do have a question though.
Sure.
There was I was also getting prosecuted for another driving offense with this prosecutor, and he said that it was all supposed to be done together though, and I haven't heard nothing about that.
I'll be filing a dismissal on that later today, Your Honor.
Yeah, you get that on file.
Yep, so there, Mr. Bayonetti stated on the record that that is going to be dismissed.
Okay, I just want to make sure because I didn't hear nothing about that.
No, that's fine, good. All right, so good catch. All right, but it's your own choice to plead guilty, right?
Yes. I just wanted to make sure because I didn't hear that part, like, and I know that was supposed to be in there, so I just wanted to just to hit.
That's fine.
That part.
That's fine. All right, so Mr. Tyndall, on October 19th of 2020, were you in the city of Adrian in the county of Lenawee?
Yes.
All right, and did you at that time have in your possession cocaine in an amount less than 25 grams?
Yes.
Did you know it was cocaine?
Yes.
Okay, and you intended to possess it, correct?
I intend to use it, yeah.
Yeah, and you didn't have any legal right to use it, right?
No.
Okay, has the court complied with MCR 6.302, Ms. Van Dusen?
Yes, Your Honor.
And Mr. Bayonetti?
Yes, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights and he does have competent counsel. This court has made no specific agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them other than the agreements that were placed on the record. I'm going to refer this matter to the probation department for a pre-sentence investigation. Mr. Tyndall, I'm going to set this for sentencing on June 29.
My son's birthday.
It's whose birthday?
My son's.
Do you want a different day?
I mean, it's okay. I can do it in the morning. Okay. I just know the day, like, so I know I won't forget it.
Okay, well, you better not forget it now. All right, so I'll set it for June 29 at 8:15 in the morning. Mr. Tyndall, you have a right to be present in person, but because there's a Killebrew agreement to no upfront jail, would you like to appear via Zoom?
Yes, please.
Okay, all right. All right, so that'll be via Zoom. So Mr. Tyndall, are you currently on probation upstairs at all?
Yeah, I'm on parole, and I'm just waiting on this. Like, I've been supposed to be off parole, but like, I haven't been in no trouble since. Like, as soon as I get this done, I'll be dismissed off parole. Like, I'm waiting on this case to be dismissed so I can get off parole. Like, the day I take that plea on the 29th, I'll be dismissed off parole.
Okay, so Miss Holly, do you need to meet with Mr. Tyndall this morning, or will his parole officer check him out?
No, I need to hear from him.
All right, who's your parole officer, Mr. Tyndall?
David Face. I report tomorrow.
Okay. All right. So, Mr. Tyndall, I'm going to pop you in a breakout room with Miss Holly. She's going to advise you. You have to come and get a packet to fill out, and then also meet with the probation department for a pre-sentence report. When you do meet with them, be truthful about your background, the events that occurred, and we will see you back here on June 29 at 8:15 in the morning for sentencing via Zoom. And you better not forget that date.
I won't.
Okay. All right. I'm going to open that breakout room and hold on 1 minute. My boss is here. All right. No, we're good. So I'm going to open that breakout room. Go ahead and talk to Miss Holly, and then you can go on your way. All right. Okay. So that one. Okay, thank you, Miss Underwood. I have that file here, Miss Adams, if you want it. Okay, so this is in the matter of the people of the state of Michigan versus Zakaya Serena McKay, file number 22-21047 FH. 23 21323 FH. Ms. Van Duzen, you represent Takaya McKay?
Yes, I do, Your Honor.
All right, so I have, actually, I'm sorry, Ms. Van Duzen. Mr. Hill's been here since 8 o'clock, so I'm gonna take him next, all right?
Okay.
I apologize. All right, Mr. Hill, thank you for your patience this morning. If you would have had Judge Olsaver, you probably would have been done at 8:30, but Mr. Malaro tends to go to Judge Olsaver first. So this is in the matter of the people of the state of Michigan versus Rodney Lamont Hill. We have two files, 22-21189 FH and 22-21190 FH. I have Salvatore Malaro on behalf of Mr. Hill and Alexander Bayonetto appearing on behalf of the people. And Mr. Hill, I didn't mean that he's assigned to go to Judge Olsaver first. Not that he prefers Judge Olsaver to me, just that he's assigned to go there first. So, Mr. Malaro, how would you like to proceed with Mr. Hill? Oh, Mr. Hill, did you get your fingerprints taken yet?
I tried to go down there this morning because somebody gave me the wrong time of going down there. I didn't know it was 7:30 to 8 o'clock, but I tried to go to the jail. They said if I could get paperwork from you to them, I could go get them taken at the jail.
All right, so Ms. Adams, could we send the order for fingerprints to the jail?
Okay.
Okay, we will do that. So Mr. Hill, then you can do that. All right, so Mr. Malaro, I see emails. Is my understanding Mr. Hill is going to take a plea today?
Yes, Judge.
Okay, so Mr. Malaro, what is the plea offer that's been made?
So Judge, it's my understanding that Mr. Hill is going to plead guilty to 1 count R&O. And then the 189 FH file, she's going to plead guilty to use. And all other matters will be dismissed. There will be no Killebrew to no immediate jail and or prison. And then we did a bench conference where there was a Cobb's to 12 months probation.
Okay, so let's back up a little bit. On file number 22-21189 FH, there's going to be an added count 3 of use of cocaine, which is a, what is that, a 1-year misdemeanor?
Yes.
Okay, so it's gonna be count 3, use of cocaine. So you'll get that amended information to us today, Mr. Bayonetto.
Yes, sure.
And then on file number 22-21190, Mr. Hill is going to plead guilty to what in that file?
1 count of R&O, Judge.
Okay, so he's going to plead as charged to count 1, and then the habitual offender 4th offense notice would be dismissed.
Correct.
Okay. All right. And so, okay, got it. And then there's no upfront jail and 12 months probation. Okay. All right, on both those files. All right. So Mr. Hill, want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, can you state your full name for the record?
Rodney Lamont Hill.
All right, so Mr. Hill, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention on file number 22-21189 FH to plead guilty to an added count 3 use of cocaine, which carries a maximum penalty of up to 1 year in jail, with an agreement there would be no upfront jail?
Yes, ma'am.
Okay, and on file number 22-21190 FH, is it your intention to plead plead guilty to count 1 R&O, which carries a maximum penalty of up to 1 year in jail, with the agreement there would be no upfront jail?
Yes, ma'am.
Judge, I think that R&O is a 2-year.
Oh, I'm sorry, which carries a maximum penalty of up to 2 years. I'm sorry. Is that correct, Mr. Hill?
Yes, ma'am.
All right, are you satisfied with Mr. Malaro as your attorney and the advice that he's given you?
Yes, ma'am.
Okay. Now, do you understand, or I'm sorry, there's a Killebrew agreement and a Cobb's, no, just a Cobb's, to no upfront jail and 12 months probation. But other than that, neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Malaro?
That is correct, Judge.
Is that correct, Mr. Bayonetto?
Yes, Your Honor.
And Mr. Hill, is that correct as far as you're aware?
Yes, ma'am.
All right, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, ma'am.
Mr. Hill, how do you wish to plead to the charge on file number 22-21189FH that on or about July 6th of 2022 in the city of Adrian in the county of Lenawee that you did commit the offense of use of cocaine, guilty or not guilty?
Guilty.
And Mr. Hill, on file number 22-21190FH, how do you wish to plead to the charge that on or about November 3rd of 2022 in Raisin Township in the county of Lenawee that you did commit the offense of police officer assaulting, resisting, or obstructing, guilty or not guilty?
Guilty.
All right. You, has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, ma'am.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, ma'am.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Malaro?
No, Your Honor.
Mr. Bayonetto?
No, Your Honor.
All right, so Mr. Hill, there's a pretty comprehensive agreement that there will be no upfront jail and 12 months probation. But other than that, has your attorney promised you any particular sentence in terms of fines, costs, or terms of probation, or estimated what that sentence will be?
No, ma'am.
All right. Is it your own choice to plead guilty?
Yes, ma'am.
All right, so let's start with file number 22-21189FH. So Mr. Hill, on July 6th of 2022, were you in the city of Adrian in the county of Lenawee?
Yes, ma'am.
And at that time, did you use cocaine?
Yes, ma'am.
Did you know it was cocaine?
Yes, ma'am.
And did you have any legal right to use cocaine?
No, ma'am.
All right, Mr. Bayonetto, are you satisfied?
I am, Your Honor, yes.
All right, so Mr. Hill, let's move over to file number 22-21190FH, which is the one I think we need prints on. But Mr. Hill, on November 3rd of 2022, Were you in Raisin Township in the county of Lenawee?
Yes, ma'am.
Oh, I'm sorry about that. And at that time, did you come in contact with a police officer from Raisin Township?
Yes, ma'am.
All right, and according to my felony information, would you agree that, or would stipulate that it was Officer Briggs from Raisin Township Police Department?
Yes, ma'am.
All right, Mr. Malaro, perhaps you could voir dire as to what occurred?
Sure. Oh, wrong one. So, Mr. Hill, is it true that on November 3rd, 2022, in Raisin Township, County of Lenawee, State of Michigan, that you in some form obstructed Officer Briggs?
Yes, sir.
And in that obstruction took place where you were on a motorbike and he pulled you over?
Yes, ma'am. Yes, sir.
And after your initial contact with Officer Briggs, you made a feeble attempt to drive away on the motorbike?
Yes, sir.
You got a
Did you say a feeble attempt?
Yes, I did, Judge, because he didn't get away.
Okay, all right, I've never heard, okay, go ahead.
You went, I think you made it about what, 10, 15 feet?
Yes, sir.
All right. And you agree that that was an obstruction of Officer Briggs' attempt to effect the traffic stop?
Yes, sir.
And he was in uniform at the time?
Yes.
And you knew he's a police officer?
Yes.
And you knew you were not in a position to be able to drive off at that point in time?
Yeah.
Is the court satisfied?
Well, let's start with Mr. Bandetto.
I am satisfied.
Anything further add?
No, Your Honor.
All right, has the court complied with MCR 6.302 B, C, and D? Mr. Malaro,
It has, Your Honor.
Mr. Bandetto?
Yes, Your Honor.
I'm going to accept the pleas. They've been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. Miss Adams, I believe, I thought one of these was set for trial. Maybe not. So we will, let's see. This court has made no agreement regarding the possibility of a plea or possible sentence in this case that the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. Mr. Malaro, are you available on June 29 at 8:15 via Zoom for sentencing?
I am, Your Honor.
All right, so Mr. Hill, I'm going to set this for sentencing on June 29. There is an agreement to no upfront jail, so would you like to Zoom in for sentencing, or do you want to come in person?
I could zoom in, Your Honor.
Okay, so I'll make that via Zoom. So Mr. Hill, I am going to place you in a breakout room with Miss Holly from the Michigan Department of Corrections. She will give you preliminary instructions on how to proceed at this time. So when you'll have a packet to fill out, and then you'll have to meet with the probation officer in person, and then they'll prepare a pre-sentence report. We'll assign that. We'll receive a copy. We'll send it to Mr. Malaro. Kind of contact him about a week in advance of sentencing, and he can review that with you. Be truthful with the probation department about your background, the events that occurred. And we will see you back on June 29 for sentencing at 8:30. Yes, sir.
I got a question.
Judge, could we address an issue of bond first?
Yeah. Hold on.
So on April 12th, when we were here last, Judge, you noted that Mr. Coast had reported that Mr. Hill was doing very well on his drops. He was clean on all of them. He informs me as of yesterday that that is continued. These drops pose a financial hardship on him. And since he has such a good record, we'd ask the court to negate the requirement to leave drug screens. I would suggest the court could allay any concerns it has by asking him to drop on the day of sentencing if it has a concern about any continued use.
All right, so Miss Adams, I will amend his bond conditions and remove the clause requiring him to do drug testing. Mr. Hill, based upon the fact that you've done really well in this long period, I will remove that clause. Is that your question, Mr. Hill? Okay, so I'm gonna open up that breakout room. Go ahead and go talk with Miss Holly, and we will see you back via Zoom on June 29 at 8:30 in the morning, all right?
Okay, thank you, Your Honor.
Thank you, Judge.
Yep, go ahead, join that breakout room, and you can just disconnect when you're done. Okay, so, there we go. All right, so back on the record in the matter of the people of the state of Michigan versus Tyndall and McKay. Ms. Van Duzen, how do you wish to proceed today?
Your Honor, in this matter, we're going to plead not guilty, ask for another pretrial in this matter, but I'd like to address bond.
Okay, so I will continue the not guilty plea on both contempts as well as the underlying offense. You want it as well on the contempts?
I think she pled guilty on the contempts because she's doing, you gave her 90 days.
No, she pled. Let's see, I have contempt, violation of bond, and failure to appear. Miss Adams, are you back there?
Excuse me.
Did you?
Hold on.
Ms. McKay, did you plead guilty?
No. She pled not, or Ms. Takaya McKay pled not guilty.
Okay, Your Honor, we'll plead guilty to the contempt of courts.
Okay, hold on one second, hold on. So here's these, here's this. Okay. All right, so, okay, so let me double check. So I only have the contempt of courts on file number 22-21047FH. So, okay, so your client will plead guilty to the contempt of courts today, or you want to chat with her real quick?
Yeah, she'll plead guilty to those.
Okay. All right, so Takaya, oh, and then I have Christopher Fleming appearing on behalf of the people and John Van Dusen on behalf of Takaya McKay. All right, so Takaya McKay, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, so Takaya McKay, I have a message from another attorney. Do you prefer pronouns they, them?
I can't hear you.
I don't know. I had a message from an attorney, and I don't know if they were referring to you or somebody else that you prefer gender neutral terms. Is that you or somebody else that I missed?
No, that's somebody else.
Okay, well, whoever it was, I probably offended them. So, okay. So, Ms. McKay, thank you. So you've heard the statement of your attorney. Is it your intention to plead guilty on both of the contempt of courts?
Yes, Your Honor.
Now, Ms. McKay, one of the contempt of courts on file number 22-21047FH is that you have failed to appear for a pretrial on February 15 of 2023. Do you understand that?
Yes, Your Honor.
The other contempt of court was for a violation of bond conditions, in that you are not to have any contact with the individual with the initials of JY or be at their residence, and that on March 18th of 23 at 3 p.m., you were located at their residence after the individual JY called and notified the police. So do you understand those are the two contempt of courts?
Yes, Your Honor.
All right, do you understand the maximum penalty for contempt of court could be up to 93 days in jail?
Yes, Your Honor.
All right, is it still your intention to plead guilty to those contempt of courts?
Yes, Your Honor.
All right, so Mr. Fleming, then Mr. Fleming, I guess on the underlying files, has a plea offer been made to Ms. Van Dusen?
Not on the latest one, Judge. On the original, the first file, the 1047 FH, there was an offer of DV second. but we haven't discussed with the latest case.
That's correct, Your Honor. We just need a pretrial out a couple weeks, so we have time to discuss it. This last file just got upstairs.
Okay, and Ms. Van Duzen, I just want to remind you that the new file occurred while she was on bond on the other file.
Yes.
With the violation of bond conditions and the failure to appear. So, all right, so on those underlying files, I will continue your not guilty plea. And then how far out do you want a pretrial, Ms. Van Duzen?
30 days would be fine.
Okay, so let's see. About June 21 at 8:30 in the morning.
That'd be perfect. And if I could address bond, and we'll do the
Let me do the plea and then you can address bond, all right?
Okay. Yep.
8:30 for the pretrial, now the contempt of court, guilty, and okay. All right, so sworn in, I asked for that. Okay. So, Ms. McKay, are you satisfied with your attorney and the advice that they have given you?
Yes, Your Honor.
All right, now, do you understand that you do have a right to contest these contempt of court charges and to have a trial on them?
Yes, Your Honor.
Do you understand that throughout this trial, you would be presumed innocent until your guilt is proven beyond a reasonable doubt? You understand that?
Yes, Your Honor.
You have a right to have all the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions, or you may ask them yourself, and to have me order any witnesses you might have to appear at that trial. Do you understand all of that?
Yes.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes.
On the other hand, do you understand that you have a right to testify at your trial if you want to testify?
Yes.
So, Ms. McKay, how do you plead to the charge that you did commit a contempt of court by failing to appear for a pretrial on February 15th of 2023? Guilty or not guilty?
Guilty.
All right, and Ms. McKay, how do you wish to plead to the allegations that you violated your bond conditions and are guilty of contempt of court by having contact with the individual with the initials of JY and being at their residence in violation of the bond conditions? Guilty or not guilty?
Guilty, Your Honor.
Okay. Has anyone promised you anything to get you to plead guilty?
No, Your Honor.
Do you understand that by pleading guilty, you're be giving up your right to a trial?
Yes, Your Honor.
Okay. And Miss Adams, could you let the jail know I need Rio Reed after this? All right. So has anyone threatened you in any way to get you to plead guilty?
No, Your Honor.
If I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes, Your Honor.
All right. Is it your own choice to plead guilty?
Yes.
All right. So, Ms. McKay, on this file, your underlying charges are domestic violence, third offense with a habitual offender, second offense notice. And one of the bond conditions in this case is that you are not to have any contact with the alleged victim in this file with the initials of JY or to be at their residence. Is that correct?
Yes.
And on March 18th of 2023, around 3 p.m., were you located at JY's residence?
Yes.
Okay, and you knew you were not allowed to be at that residence, correct?
Yes.
Okay. And then, Ms. McKay, this matter was set for pretrial back on February 15 of 2023. And did you fail to appear that day?
Yes, Your Honor.
Okay. Were you incarcerated?
No.
Were you in the hospital?
No.
You just chose not to come?
Yes.
All right. I accept the plea. It has been given, both pleas, they've been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. Ms. Van Duzen, so at this time, you have an opportunity to both address bond and say something on behalf of your client for sentencing.
Yes, Your Honor. McLean has already been in there 60 days for the contempt of court. She understands violating for having contact with the defendant or the alleged victim, along with that she needs to show up for her court cases. I've talked to her mother in this case. Her mother's allowing her to come live with her, along with has 2 jobs lined up for her. One would be at Martin Ria, which she was working there prior, and they said she could come back. So I'd ask the court to allow her a PR bond.
Mr. Fleming?
Thank you, Judge. I would just point out to this court that the defendant has now pleaded guilty to violations of bond. She was on bond for a DV third when she picked up the newest case for assault GBH on the same victim, Judge. People would request that bond remain the same.
All right. Ms. McKay, bond conditions are really important to the court. Because one, if there's an alleged victim, obviously you are deemed innocent until proven guilty. But if there is an alleged victim, bond conditions are put in place so that I can allow you to get out of jail and I can protect any alleged victim. And so the court does take very seriously violation of bond conditions. Ms. Van Duzen, I'm going to move your pretrial up to June 7. But I am not going to release her on the pretrial, but I will move her for pretrial or release her on bond. But I will move the pretrial up just a couple weeks from today. Is that all right? So we'll set pretrial June 7 instead of June 21. And Ms. McKay, with regard to sentencing, is there anything you'd like to say on your own behalf?
Your Honor, I'm sorry, but please, I gotta get out, please. I don't want to lose my jobs or nothing like that. And now being around Jennifer still been trying to contact me while I'm here, and they've been blocking her and everything. It's like nobody looked at my side of the story ever, and I keep getting blamed for this, and it's just not me. Like, I put a report out on her too, and she never got sent to court or nothing. And I just want people to look at my behalf too. And I've been in here, I learned my lesson, and I showed the officers the text message of her telling me to come over there that day. It's not like I was just going over there.
Well, Ms. McKay, at the end of the day, I don't care how much she contacts you. You can't have contact with her, and you have to show up for court. So it's sentence of court on the contempt of court. She'll serve 90 days in Lenawee County Jail, credit for time served. We can readdress bond on June 7th, Ms. Van Duzen, and I moved your hearing date up, so it's just a couple weeks out instead of a month out. So Ms. McKay, we'll see you back here on June 7 at 8:30 in the morning. Ms. Van Duzen, you'll do the stip in order to adjourn?
Yes, Your Honor. Thank you.
All right, thank you. You're all set, Ms. McKay. So I have a gentleman joining me from the jail. What is your name?
Rio Reed.
All right. And which prosecutor here was on the case with Tamiris Hennigan involving the tractor?
That's mine, Judge.
Okay. So Mr. Fleming. All right. So this is in the matter of the people of the state of Michigan versus Rio Ernesto Reed, file number 23-21349FH. I have Salvatore Malaro appearing on behalf of Mr. Reed, and I have Christopher Fleming or Isaac Sneed appearing on behalf of the people. Don't go anywhere, Mr. Fleming. So this is the date and time set for arraignment in this matter. Mr. Malaro, do you waive the reading of the felony information?
Yes, Your Honor. At this time, we'd acknowledge you see the information. Waive its reading in open court as the counts 1, 2, and 3. My client would plead not guilty to those offenses. I do not see any habitual attachment. We'd also acknowledge receipt of the witness list. Yes, court to enter a not guilty plea and to schedule a matter for pretrial, and then would like to be heard on the issue of bond.
All right, so, Mr. Sneed has, or Mr. Millar, has a plea offer been made in this file?
No, not yet, Judge.
Okay. All right, so I will enter a plea of not guilty on Mr. Reed's behalf. And, I'll set another, how far out do you want to pre-trial, Mr. Millar? I have like June 21, is that good?
Yeah, that should be fine.
All right, we'll do the notice because it was an arraignment. So we'll set pre-trial on June 21 at 8:30 in the morning. And Mr. Millar, you may now address bond.
Oh, Your Honor, Mr. Reed's a long-term resident of the county. This involves more of a domestic dispute than it does the seriousness of the home invasion. We are awaiting the results of a subpoena with respect to the party's residency in this issue, which I think would resolve the count one if it turns out to be as we think it does. And I know spoken to the prosecutor about that, he probably is of a different view on that, but we at least need to look at that information. I think a no contact provision would be sufficient. Mr. Reed would like to be out so that he can assist in a more efficient manner his defense of these matters. And so we'd ask the court, the current bond on each count is $10,000 on count one, $5,000 on counts 2 and 3 for a total of $20,000 cash or surety. Judge, at the prior in district court, we weren't aware of the issue pertaining to the lease. And I think that would certainly would pose a change on this matter. And so we'd ask the court to consider reducing the bonds to perhaps $1,000 on count 1 and $500 on counts 2 and 3. That would be our request, Judge.
All right, Mr. Sneed, any position on bond?
Yes, Your Honor, the people would ask the bond remain as is. We discussed this purported defense that the defendant wishes to present a lease that he was on for a unit 10 and that Miss Quinones rented a unit upstairs. I pointed out this is not a valid defense in light of the personal protection order that Miss Quinones had against Mr. Reed, in which her address is identified on that personal protection order as unit 10. That's the unit that he entered in violation of the personal protection order without permission of Miss Quinones, and which led to the home invasion charge being sought. So there is no issue regarding a lease. It's not a valid defense. There hasn't been any change in circumstances since the last bond hearing we had down in district court, where the amounts were set based upon the seriousness of the charges. Ms. Quinones has been before Your Honor in the past, I would surmise. She took the steps of getting a personal protection order against Mr. Reed. He violated it and assaulted her by taking away a cell phone in violation of the personal protection order. And that led to these charges before the court today. So we're asking bond to remain for the protection of units. Thank you.
So Mr. Sneed, just to clarify, so Ms. Quinones lives in apartment 10 and he lived upstairs in the same building but a different apartment?
I don't know where Mr. Reed lived, Your Honor. They may have cohabitated for some time at some point in unit 10 together, but the fact is that personal protection order prohibited him from entering that unit, and that's what led to the charges before the court today. So as I've explained to Mr. Malero, the lease is no defense, whatever it says.
Okay, so Right, Mr. Malaro, I am not going to change his bond at this time, but I will move his pretrial up closer. So it's not as far out. I will set this out to May 31. So I'll set the pretrial for May 31. That should give you both ample time to meet and discuss the case and see if there's a resolution. So I'll set it for May 31 at 8:30 in the morning. And because it's an arraignment, my office will do the notice of hearing. All right, so.
If I could
We'll
just
see
correct
that.
a record too, Judge, before we go off. record.
You know what, Mr. Steve, we're really having audio issues with you, so
All right.
I'm sorry.
I was gonna say, we did offer a sole count of home invasion third as the offer.
Home invasion third, and that's a 5-year.
Yes.
All right, so Mr. Malaro, we'll see you back then on May 31 at 8:30 in the morning, okay?
Yes, Your Honor, thank you.
All right, and Mr. Fleming, don't leave. That does conclude